Talk Show.
Recorded live.
I'd like to welcome everyone to this Wednesday, April 16th edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Welcome to the revival of the study of equity, its principles, doctrines, and rules of equity in opposition to the tendency giving an undue prominence and superiority to purely legal rules and ignoring, forgetting, or the suppression of equitable notions. And welcome to A Crier in the Wilderness. Hear ye, hear ye. Take notice, God's court is now in session. For repent, for the Lord's kingdom and its enforcement is near. We left off in Pomeroy's book, Equity Jurisprudence, Volume 3, Section 1140, on the limitations and intentions of the testator. That's Section 1140 on page 551 in the PDF or 2644 in the book. That's Section 1140. So take notice and acknowledgement of the agreement that this shall enter documents is a private confidential arrangement not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show enter documents are for academic and informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties, in preparation of use of herein reference, and has no interest in any use referenced therein, is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons of communication between the parties. By reading or using this information, you acknowledge and agree you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for commercial damages of $200 million or more, per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Now, as usual, we need a definition of what equity is, and I go none other than John Bouvier's Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4, which states, law is nothing without equity, and equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as assistance for those who have weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. Now remember, it doesn't matter how many people don't believe it. What matters is whether it's true or not. And that takes us to my pet peeve, which is public versus private. People can't tell what's private from public, and everybody's thinking is all backwards. What they think is private is really public. Public is everything by default. So we need a definition. A definition of private is any relation that you imply or express which is your intent as a special one. And the next question I always ask is, when did you ever express your intent form any relation as a special one? And the answer to that technically is really no, never. So all your relations are then public. So why do I say never? Well, that comes down to knowing what this special relation is all about. And that's what NTT, New Trust Technology, was all about. How to create this special relation. Unless it's done in a specific and special way, it's not private. You just can't say this is a private conversation. No. It's not a private conversation. Everything today is defaults to public. And I use the example of the private conversation you're having with your neighbor in your backyard across the fence. You think it's all private because you're in your property, and you alone is you and your neighbor. And you think it's private. Well, being alone out anywhere does not make it private. It's still all public, period, by default, because you didn't do anything special to create a special relation, a private relation. So then all your relations are then all public, you just don't know it. Now that takes in the doctrine of election out of Pomeroy's book, section 461, that the thing that you choose, when you have two or more things to choose from, the thing that you choose substitutes for all the rest. And you waive the rest. So consequently, what you think is private is really not. Everything's all public, unless you do something special, unless it's done under a private trust, formed under a private trust, which NTT explains how to do, in order to really say it's a private conversation or a private relation. So this intent for this private relation, keep in mind under trust law, no party in a trust needs to know a trust is being formed. That's restatement second. That's restatement of anything. 1 and 2, 3, they're all the same. No party in a trust needs to know a trust is being formed. Now, I didn't say about enforcing a trust. I said forming a trust. That takes us to LGVA versus Belleville Farms, 2011 case out of the Courts of Special Appeals of Maryland. It says it is to be noticed that an express trust may arise even though the parties in their own mind did not intend to create a trust. Well, right away, everybody would think, well, how could that be? If it wasn't in my own mind, not an intent to create a trust, then how can it be a trust? Well, just what I said, trust law is no party in the trust needs to know a trust is being formed, period. That means grantor, trustee, and beneficiary do not need to know they're forming a trust. Now, let me give you an example of that. I give you my pen to use. And I say, I want it back after you're done using it. That was a trust. I had specific trust res, my pen, gave you a duty. The duty was to use it and return it. I was the grantor. You were the trustee. And it was for my benefit. I'm beneficiary. All the parties there are necessary to form a trust. Got the delivery of the trust res, the pen. I got the method of formation. Now, nobody in the relation knew that that was a trust relation, but it was. It had a specific thing with a duty for a third person. That was a trust. And that's how easy it is to form a trust. It says to be noticed that an express trust may arise even though the parties in their own mind did not intend to create a trust. It is the manifestation of intention that controls. In other words, manifestation of intention, that's your actions and your deeds, written down on a piece of paper, a record. A record manifests your intention. That's what NTT is all about, how to create a record of a private trust so that you can manifest that it is a private relation and prove it. It is the manifestation of intention that controls and not the actual intention. Actual intention, that's having actual knowledge. Remember, no party in the trust, an example that I gave you, had to know that they were forming a trust. That doesn't prevent a trust from not forming. How many trusts do you think you have out there that you're not aware of that you formed? It is the manifestation of intention that controls and not the actual intention, where that differs from the manifestation of intention. An express trust may be created even though the parties do not call it a trust, And even though they do not understand precisely what a trust is, bingo. Even though they do not understand precisely what a trust is, it is sufficient of what they appear to have in mind is in its essentials what the courts mean when they speak of a trust. And they're going to give you the trust test. And the trust test is really nothing more than the elements necessary to form a trust, which is intent, purpose, parties, specific trust res, and a method of formation. And you've got a trust. Bingo. It's that simple. That special intention to form a private trust. NTT all the way. Now we go to Adams' quote, where Adams, out of the Origin of English Equity, he quoted that we may confidently assert that equity and common law originated in one and the same procedure. That during the first 200 years of their history, they were not distinguished from one another. And that if we now distinguish between them during that period, we do it artificially by application of tests impossible to contemporaries. It's well on to the 14th century before we get any clear distinction between equity and common law. They finally realized that equity was distinct from common law. And they finally figured out that it was common law was created by equity. In fact, all your law forms were created by equity. You just don't know it. Here they thought, what we want is the unwritten part of the common law. We think back, prior to the 14th century, say. 1215, say. Magna Carta times. Oh, we want that unwritten part of the common law. That's what we want today. Well, I got news for you. The thing you want today, by definition, common law is the law form that is common to all people of the particular time. Of the particular time of today, the law that is common to all people is statutes and codes. That is your common law today. You've been duped by wordsmithing. It's not a common law being a noun. It's an adjective describer of the system that's in place at the particular time. And what you really wanted, what was fair, just, and right, which you say is the unwritten part. Here, the unwritten part, the thing that's fair, just, and right, that by definition is what equity is. Now, if you come to the distinction of the separation of it, bingo, you got it. Here you've been wanting common law all along, and it's not what you want. What you want is equity. Equity is the soul and spirit of the law. Everything else is construed or made by it. Get the distinction. Equity and common law are not the same. You've been in the wrong jurisdiction, asking for the wrong things, and trying to shove your substantive rights down that common law throat, or statute and code jurisdiction throat, and you wonder why it never happens. I'll tell you why. Because the subject matter can't be heard in that court system. You're in the wrong jurisdiction. You're on the wrong stage, dancing the wrong tune, using the wrong tools, asking for the wrong thing. That court can't give you any substantive rights. You want equity. Equity is fair, just, and right. That's substantive rights. You're under the judgment of the law. Statutes and codes is the judgment of somebody who is not living equitably. It's getting this confusion straightened around. That's very hard to do because everybody's got a source of material that's off base and skewed. And people don't know how to have discernment. And really, you put the eyes of discernment on by having the understanding of equity. And you will view the law differently. That's our problem. We need to put the eyes of equity on like a pair of glasses so that you can see more clearly, and you will view the law differently. You will view the law, being statutes and codes or common law or admiralty or any other jurisdiction, as being the enforcement, 1/10 enforcement of the 9/10 equitable principle. So the whole law is really equity and whatever other jurisdiction for enforcement there is. 9/10, 1/10. 9/10 equity, 1/10 whatever jurisdiction enforcement. We weren't designed to operate by statutes and codes. We die by the letter of the law. We were designed to operate under equity, which is grace. And by equity, grace, you live. It's much easier to understand principles of maxims of equity than it is to understand and memorize 63 million statutes and codes. You were never meant to do it. It's impossible. We left off in section 1140, limitations and intention of the testator. It says this doctrine, although nearly universal, may still be overcome by contrary intention of the testator plainly expressed in the will. If a testator uses language sufficiently showing an intention that a certain legacy or legacies otherwise general shall have preference and be paid in full before the others, and not abate pro rata with them, such intention will be carried out, and legacy or legacies will be preferred, although general. Footnote 1. Case cites to support that. Back into the text. Some additional rules showing what language will or will not sufficiently express such an intention will be found in the footnote. Next section, 1141, exceptions. Legacies to near relatives. It is a settled rule of equity independent of statutes that among general legacies there is no precedence, no exemption from pro rata or complete abatement in favor of the legacies to a wife, child, or a near relative of the testator. Footnote 1. Case cites to support that. Back in the text, if, however, the testator shows an infant to give such legacies the preference, his intention will be followed, and the court of equity will easily discover such intention in favor of a widow, child, or decedent. Footnote 2. Says, see the case Lewin versus Lewin. The court leans in favor of such an intention in case of a widow or child, but against it in case of legatees who are wholly volunteers and strangers. Back into the text, this general rule has been changed in several states by statutes, which give legacies to near family relatives the preference over all other general legacies and perhaps over those which are special or demonstrative. Footnote 3. Case cites to support that. Next section, 1142. The same, legacies for valuable consideration. One exception to the general rule of abatement has always been admitted by courts of equity. A general legacy given for the valuable consideration, as, for example, to the widow in lieu and satisfaction of her own dower, or to a creditor in payment or discharge of a debt, has priority and does not abate with other legacies provided the dower right or the debt still existed at the testator's death. Footnote 1. Case cites to support that. Stanford versus Stanford, a legacy in lieu of the dower is only entitled to preference in payment out of the personal property and is not charged on the estate, on the real estate. Back into the text. Next section, 1143. Appropriation of a fund. If a particular fund has been set apart and appropriated by the executor for the payment of a legacy with the consent of the legatee, and afterwards, through the wrongful act of the executor or otherwise, his fund becomes deficient, the legatee is not entitled to contribution from other legatees of the same class. in order to make up the deficiency, but can only resort to the residual if any be. It is otherwise if the appropriation was made without the consent of the legatee in the case that he is entitled to call upon all the legatees so that the loss should be borne by all of them ratably. Footnote 1. Case cites to support that states that the reason for this distinction is that where the legatee has consented to such an appropriation, he has made the executor his personal debtor, and he has, if it were, received payment of his legacy and then loaned it back to the executor, but in the other case, the act is that of an executor alone. Back into the text. Next section, 1144, lapse legacies. When the legatee is dead at the same time of making the will, or dies afterwards during the testator's lifetime, by the common law rule, the legacy to him is said to lapse, and the gift to him fully fails, and it does not pass to his personal representatives, next of kin or heirs, nor has he the power to dispose of it by his own will. In short, the legacy becomes entirely nugatory. The same general rule of the common law applies to a devise of any real estate. Footnote 1. Case cites in support of that. As in Brown versus Hope, this common law rule is very stringent. No mere words of the will, however expressed, showing an extent to the testator that a lapse should not take place, would prevent it. Appleton versus Rowley. The only possible mode of preventing the lapse was for the testator to substitute some other legatee or devisee in place of the first named and to whom property should go on his death. There must be an actual gift over to another legatee or devisee in case the first name dies. Case cite to support that. Back into the text. Where a gift is made to a number of persons as a class, such class to be ascertained and fixed as it exists to the death of the testator or to any other specified time, the predeceased of any member of the class will not occasion a lapse of his share, and the class as it exists at the time designated will take the whole property. Footnote 2. Case cites to support that. It says that there are one or two other particular exceptions to the general rule. The most important is a bequest for a payment of debts to the creditors themselves, which will not lapse, but will go to their representatives upon their predecease. Case cite to support that. Back into the text, wherever the legacy lapses the specific property bequeathed, if it was specific, or the amount of assets which would be request for the payment of its in general rule, falls into the residual and passes to the residuary clause, if there be one. But if there is no residuary clause, then as to such property, the testator would in fact die intestate. The amount would be actually undisposed of will, and where a devise lapsed in the common law rule, the land given by it would not fall into any residuary clause of the testator's real estate, but would decease to the heirs or heirs at law. The latter rule of the common law has been altered in England and generally in the American states by statute. Footnote 3. States that a lapsed devise is made to fall into the residual like any lapsed legacy. The reason of the common law rule was found in the doctrine that a will of land, unlike that of personal property, speaks as from the date of execution and not from the testator's death. This distinction has been generally abrogated by statute, so that in England and in most of the states, wills of real and personal property alike speak as at the time of the testator's death. Next section, 1145, the same, statutory changes. The rules of common law were generally adopted in this country and still form a part of the jurisprudence, except in the particular class or under the particular circumstances where they have been altered by statute. And such modifying legislation within certain well-defined limits has been exclusively enacted. One common type seems to have been followed. in England, the modification is confined to a legacy or devise to a child or other decedent of the testator who shall predecease living at the testator's death. The gift in such case shall not lapse. Footnote 1. Says 1 Victoria, section 26, where any person being a child or otherwise issue of a testator to whom any real or personal estate shall be devised or bequeathed, shall die in the lifetime of a testator leaving issue, and any such issue of such person shall be living at the time of the death of the testator, such devise or bequeath shall not lapse, but shall take an effect of the death of such person had happened immediately after the death of the testator. It is held under this section that the same issue need not be living at the death of the legatee or devisee and of the testator. It is enough if one person is living at the death of the legatee or devisee and another person at the death of the testator, but both belonging to the same line of issue. Case cites to support that. Back into the text. Under the language of the English statute, it is held that the issue are not substituted in place of their deceased parent, but the legacy or devisee or the devise actually vests in the original legatee or devisee to whom the testator gave it, so as it would pass by a will made by such legatee or devisee who dies before the original testator. Footnote 3. It would seem, however, that the language of some American statutes does not admit such an interpretation. Footnote 3 states that case cites to support, and this statute does not in any way affect gifts to children as a class. And that concludes the section 1. So section 2 we're not going to go into, and we're leaving Pomeroy, and from here on in we're going to the horse's mouth, so to speak. We're going to the scriptures. Changing the whole format of NTT. We're moving on to something bigger, and I always said that really surprised me that the class, or the path that we've been following all along, has moved the way it's moved. Being debt accredited to start out with, morphing and understanding that it's all about trust, finding out that trust is administered solely in equity, and equity is really the equitable maxims, and where they came from was from the God-conscious mind. The whole path has been leading us back to the understanding of who God is, how He wants us to live. He wants us to live equitably, and equity is His principles of what's fair, just, and right. And we've been going through all these different authors and gleaning their definitions and their meanings to what they say about equity, because they are more or less the source that the courts use. And really, the real source is the Bible. There are some real eye openers in there. And that's the direction we're going. So NTT, as we know it, as discussing about how to merge your estates and cancel debts and terminate, has really not changed. It's just that we're not going to discuss that facet any longer. We're moving on ahead. We're going to go and study the scriptures for equity, and we're going to study the kingdom of God in preparation of living a life of equity, administering the trust, because the private trust really that everybody's looking for is really the God-ordained trust. And there are some real eye-openers in there as to property, ownership, as to titles, as to conduct, as to morality, as to law. And that's the big question. What is law? And that's what we're moving forward on. And we're closing an era on NTT. So before we go to Q&A here, next week will be a summarization. In fact, there may be 2 weeks on summarization of NTT and what we've accomplished so far. Because in my mind's eye, I've accomplished everything I've set out to do. And from what I know, what I understand, it is finished. What I can do, based on what I know, is completely different from what you know and what you can do. There's a big difference. Everything you need to get where I am and move forward is in the top 40 audios. And all the other audios are just in support of that. If you're looking for the promised land, if you're looking for the private side, if you're looking for all the money and all the wisdom, by studying what we've been studying, if you've been studying the principles, you would know that just by the principles alone, not by CW, by the principles alone of maxims of equity, you would know that this is the right path. The private trust is the right path. But if you don't understand the principles and the maxims, if you're just here kind of like fishing around, take my word for it. Drop everything else and continue studying equity, because your golden opportunity is in the pursuing of this course and finishing it. Read between the lines, people. I can't tell you certain things because it's solely private. You're just going to have to take my word for it. I'm there. I'm going to say it again. I'm there. You're on the right track. Drop all this other DC stuff and come follow me. So let's go to Q&A. Press *8 for raising your hand, getting in the line for asking a question. *8. Press *8 to raise your hand, get in the queue line. *8. Anybody? Question?
Bonjour.
Bonjour. Hi,
How you
Bob.
doing? Hey, dude. Nice to hear your voice again. Let me get on downstairs and get this taken care of down here. Yesterday I had so many questions for you for things I want to talk about, and then I'm coming down with a cold right now. It's just not the right time for all this to happen. But I'll say this: I like where we're going. I like where this is heading for. This is absolutely excellent. If nobody can understand that, well, I wish they could, because this is excellent. And mentioning the trust. And I got a section here where it's frustrated because the simple fact is that I talked before about my friend who had an accident here, and I started off the paperwork as best as I know the trust works out with Christian, and that is I did put it under special notice and notice of interest, private confidential, and I sat there and said, as grantor beneficiary, my friend, she retains all rights, title, and interest. This person has written back now, has asked us for more follow-up because otherwise he says if I don't have your cooperation, I'm going to determine that you don't want to have a claim, get your claim for the action that happened on this property. Well, I need to write to him tomorrow, and I'm going to basically tell the person that, hey, you know what, I won't talk as if I was my friend because I'm doing this letter for her. I'm going to say, hey, I have no evidence, record or otherwise, ever grant you any authority to make any determination whether there's a claim here or not. But you should have already known from the first paperwork I sent to you that the claim's already been filed, the claim's already been stated to you, and that you don't have any authority to determine whether there's a claim is in effect or not. So that's what you were saying back in the second letter to my friend here. I was going, this is nuts, man. So we got that going on right now. My other friend, he's got a really unusual situation, and give me a second here, dude. Remember I told you way back when last year we were dealing with a situation, and the paperwork we used was maybe more on the at-law side. That's a question I have for you, Christian. When you use the word executor, I was looking up that word today on Black's Law Dictionary. It's a person who performs an act for another. Now, we just talked about in tonight's show, right there at the very beginning of section 1140, talks about being an executor. Is your opinion of an executor on the at-law side or the equitable side?
Well, an executor could fit in really on both.
Okay.
But an executor on either side is really a derivative relationship. It's not the primary. The primary would be the trust and the parties in the trust or the offices in the trust. That would be the primary relationship between the trustee, the beneficiary, and the grantor.
Okay.
Any other relationship associated with that is secondary or derivative.
Okay, I seriously.
It doesn't have priority.
Okay.
Priority is from the trust. The trust has the priority relationship, not the secondary ones.
Right. Okay. And you know what? I apologize. You did mention that about maybe 2 or 3 weeks ago. I apologize for not remembering it, but I'll keep that in mind as to my time. Yeah, secondary. So the executor is secondary. The trust is always the first one. Hindsight is 20/20, but I wish I could have been with you guys sooner or gotten back into your field. But that's okay. I mean, I've come a long ways, and it's helped me out with my own understanding. My friend over in the East Coast, he's got a situation now where we've done the paperwork and held him off. It's like June till August, September last year. And now this law firm's come back in again on filed a whole new lawsuit and asking for the stuff. Now, this is my thoughts, Christian. That's why I said to my friend, I said, we have 2 ways of going about doing this. I don't know enough about equity yet to go and do this, but if we want to, we can try going equity. But that's my point. I'm worried that if we don't do it properly, we're not going to get a remedy that we want to go for. And like the guy over in England last week, I think it was, he was talking about he put his paperwork on the outlaw side to at least hold him off for the time being. So, there's a guy asking for the top list. Sorry, this has already been asked, but is there a way of getting some list of the top 40 calls he's asking for? It's guest 11. Going back onto the stuff here, I said if we go in and this new court case, Christian, is the evidence that this law firm wants to administer the estate. I said, you've already given notice in the last time back last year, back in June to August, that if they want to administer the estate, here's a fee schedule, and therefore the case was nothing happened. It was just basically dropped off and all that stuff. I believe at that point in time we should have put in a document to dissolve the case and with prejudice so that nobody could come back in on him again. I didn't know enough at that point at that time to go and do that. So I believe that this is why the law firm has come back in and said, hey, we're filing another lawsuit and going against you. Now, I believe at this point in time, they're going to have a lot more meat under the table as to how they're going to handle him if you put the same type of paperwork in again. But I said, listen, The point is this: if they want to administer the estate, there's a fee schedule. They're given those before, so we can do two things. We can put a claim in now, and this is the part I don't like. I just wish I knew more about equity. I really do. But so we can put a claim in now, and it's probably going to be on the. It could be on the equitable side, but I don't know enough yet about to invoke the court of equity property, as you guys are saying about it, and doing appeals and stuff, all that stuff, to bring it over to invoke a court of equity. Other than to say, I require this court to be a court of equity, or I require this court to be a court of equity, make it so.
Yeah, but that doesn't invoke the equity, though.
Yeah, see, that's what I'm saying. I don't know enough about that yet. That's the switches, those switches that you gave us a long time ago to do that.
Right.
So I said we can go in two ways and do this. Is you can put your claim in for the fee schedule on the at-law side that we already give him. There's a fee schedule that's been recorded on the public side for him that he's done. And so we can go put that in on the at-law side and do it. But again, as far as I'm concerned, this judge, they come back and say, well, we don't recognize your fee schedule and all the stuff like that, but we're going to find a favor of the plaintiff, and then now you're screwed anyhow. So what we can do is just go for your paperwork, and again, on the what we're doing right now, like we did the first time, and hold off the court case while we continue to study this, while we continue to study equity, Christian, and then I'd like to serve them a bill, personally, serve them a bill, give them 30, 60, and 90-day notices, and if they don't pay the bill on the 91st day, which gives us 3 more months of studying this stuff hardcore, and maybe then we'll be able to take that and bring it into a court of equity ourselves and do it properly. What are your thoughts?
Well, what I would do in kind of like that description of the scenario that you said, I would go in at it a legal sense if I didn't know enough about how to enforce the trust in equity.
Okay.
Go back in and ask, for the documentation, to prove up the note that they have standing and all that stuff. When they don't use when they don't bring in the documents, then I'm going to use the motion to compel. I'm going to use the court to get it dismissed. And usually that's pretty successful from what I can do. But what I would be doing in the meantime was be studying, get up to speed so that I could have the trust formed. And what I would have done is had the trust formed, had a special deposit in there, and use that special deposit as the payment. And if they didn't apply it, they would be in breach of the trust, and I'd be going into a court of equity as plaintiff for an enforcement of the breach of trust because the debt's already been paid because it's been extinguished. Right,
and that's actually, I thought tonight was going to be the last class, but I just heard you sit there say we're going to have probably 2 more weeks of summarization of NTT as it goes, and that's great. I guess there's a chance for me to ask more questions. That's one question. I have an idea how to do the...
Point is there would be no fee schedule. I wouldn't use a fee schedule. I would be using special deposit. You see, there's no fee schedule under a trust. There's special deposit, though, and extinguishment and merger.
A trust has to do with performance and enforcing the performance of the trustee.
Right.
Right. Like I said, I just don't, for the time being, Kristen, you just please bear with me and be patient. What we did, at least, held them off for the time being from June until August, September. When they come back now with a whole brand new court case, it's not like it's a continuation one. And I haven't even looked at his documentation that he scanned for me yet. I'm just trying to think how we can do this for the time being. But that's
mortgage foreclosure?
Pardon me?
Was this a mortgage foreclosure?
No, this has to do with a credit card situation that...
okay. In principle, though. Principle.
Yeah.
A little bit different because they're going to probably come at you under 2 phases, contract and use.
Okay. Yeah. Yeah. Okay. Well, that's
basically
why.
Basically the same, though.
Well, see, I was listening to one of your calls again this past week. I mean, one of your older calls, and you were talking about the NTT stuff. And matter of fact, I even got some of the older calls right after you were from a period of time, which is not on the talk shoe list here anymore. But it was right after your January the 17th call. I had about 4 or 5, maybe 6 calls. I was listening to them for the last few weeks, and I was these other guys who were just doing it. It was interesting to hear what they had to say, but they used to be on your talk shoe list, but I don't think they're there anymore. I'm pretty sure they've been removed. But it's just something I was just trying to think, how can I help out my friend at the time being while I'm learning this equity stuff here. And that's why I say to you, maybe we have to buy 3 months period of time to get this under my belt, because I said, I think for everybody who's listening on the call here right now, Christian, is I was listening to you the other day again on the call, and it's going, man, it's almost like I feel like I should go back and study the UCC just so I can understand it. And like one of the things is this, is like you mentioned in the call, Christian, was you sat there and said that when let's say I'm dealing with you and you don't pay your bill, and now I go and sell it to I buy the debt from Citibank, and I got it now. You were talking about the UCC code. You're talking about how then you, as a debtor, you lose all rights, and that's what holder due course is all about. I'm going, this is incredible stuff to know, because, well, I don't want to talk about push on the outlaw side, Chris. It's just to me, it's important to know how the other side is going to come at you, where they're coming at you from. Say, oh, I recognize that. They're coming at you from the UCC stuff.
Legal point of view under commerce, and it's going to be based on UCC.
Right, and I'm saying if we can recognize what they're coming at us and how they're coming at us, bang, then you can go right there in the equity and just knock them down dead. Knock them upside the head a few times. And it's like you said, just go, wow, it's like you don't pay your bill, and now that company sells the debt to a debt collector or whoever it may be, and like that. And also now what happens is you sat there and said on the UCC code on it, you talk about Article 3, 1, 2, 3, and 5, and I think as well as 8, I think at one point, and maybe it was the other guys talking about 8. And you're talking about that, how that when that happens, then the person who's
the way to get them is make them produce the records, and they usually can't produce the records. And then if they can't produce the records within the time limit of discovery, then you've got them on a silver platter. You got the win. You just have to move.
So when you ask them to produce a record, you're not talking about like a credit card statement and all that stuff, are you? You're talking about the actual application with the signature on it.
Well, how did you apply? Yeah. You had to sign. Produce the documents where I signed.
Yeah, you have to have it somewhere.
If you want to say, I forget the two terms exactly what it is now.
Yeah, it's been so long.
One's on a contract, and the other one's account stated and account. What was the other one? Account stated and whatever. But anyway, it boils down to one's a contract. Yeah, what the two terms are usually come. The count one is money of account or whatever, and then count two is usually something else. But anyway,
right?
It's by your use of the
product,
the goods. Yeah, the goods and service. You get the use of it, then you owe the debt.
Right.
So if there's no contract, say, they'll get you on the other one, because you got the use. But there still has to be proof that you got the use of it. And they don't have that documentation either. Okay. So they're unable to come up with either one of the documentation to prove both those two counts.
Okay.
Now here's the thing. They were supposed to have that information in their hands at the filing of the case in order to have standing to bring forth an action. If they can't use the documents that they're supposed to have within the time limit of discovery, which is 30 days, when they don't produce it, you just won.
Okay.
Proves that they didn't have the document at the filing.
Produce it. You didn't have the document at the time of the filing. Okay.
Standing has to be at the filing.
Standing has to be at the filing, not later on.
Or later on down the line.
When you ask for discovery then.
Yes.
Okay. I'll keep that in mind. I'll have to download this audio for sure. Now, the other thing is just my friend, getting back to my friend who had the accident on government property. It was during there was a hurricane warning. They were all told to go in the basement. She ended up falling down, took down the stairs, and she broke her ankle and all that stuff. And this, I told you a little bit about that in the past few weeks here, Christian. And this guy's coming back again saying he really needs your Social Security number. And I'm just going like this. I'm having a real problem with this. Why are you asking for the Social Security number? I mean, I understand the thing and the live, a live human being or a woman or like that, but I just having a problem with this guy when we've already put the documentation to him and she signed the documentation saying that she's a grantor/beneficiary and that this notice was under such deposit. So why is he still coming back to us saying, well, I need to make a payment. I need your Social Security number. To me, what he's doing is this, Christian. I read the document and the so-called law that he gave with his previous letter was that there, to me, what's going to happen is this. If this insurance company can shrug off any liability or of a monthly payment, where you want to call it that way, to the disability office of the government, Social Security Disability Office, they're going to do that. And then that'll let them off the hook. And all of a sudden now my friend will be under the rules and regulations of the government and dictate to her what she can and can't do on Social Security Disability. Now, she's not on, she has no need for it right now, nothing at all. She's totally fine. She's back to work. But why are they asking for a Social Security number? That pisses me off. I know about the thing, and I know about that she's one of the people, I'm one of the people, and you're one of the people, but this is getting ridiculous that how now every day, because I remember reading about a few days ago how back in the late 60s and 70s we were told to keep our Social Security number quiet. Now it's like everyone's asking for it. Without it, they can't do business with you. I'm going, holy shit. A woman was hurt here. An actual woman being was hurt here on your property, and you're asking her to get Social Security so you can pay a thing and put a liability back on her. Why?
Sign of the times. Everybody's got to have the 666 number to do buyer.
Yeah. So you don't see any way I can get around that right now, do you?
As to giving the Social Security number?
Yeah, by not giving one.
Why not?
I was thinking about this. Hey, if you want to minister the estate, here's the fee schedule on the private side to minister the estate. Because as far as I'm concerned, look, the accident happened on your property. The stairs that she fell down are of unusual size stairs. They are not normal length and height and rise stairs. And
I'm not exactly straight on why they want the Social Security number again.
Yeah, it's just the guy's saying I can't make a payment to you until I have your Social Security number. And then there's a law that talks about going with the that they have to report to the Social Security Disability Office and all that stuff. And well, hold on a second, she's not disabled. So why are you referring to the so-called law and stuff? I'll take care of it tomorrow. I'm writing a letter saying I asked you for information like that stuff. But I'm just pissed off because this guy seems to think that he says he wrote her a second letter which she got probably Friday. And he says, I haven't heard from you for a while. If I haven't heard from you, I'll think that you don't have any intention of making a claim. Well, I'm going, holy shit, man. The first letter said, notice of interest, private, confidential, this has been done. And the guy's even admitted that, that she broke her ankle on their property. So, why the hell would she able to have a claim on that stuff? Put a claim on the insurance company. And the stupid thing is this. I was there in the hospital when she was getting her cast in her leg when the two medical technicians came up to her and said, look, we have to tell you by law that you can't, because the cast is on your right foot, you cannot drive a car. And they gave an actual example, Christian, of a lady who actually said, well, I'll take a chance. She got into an accident. It was not her fault. It was the other guy's fault. But this lady, because the insurance realized that she had a cast in her foot, they would not cover her. So she had someone else, she paid someone else to take her to work all the time after she got into physical therapy and all that stuff. And now this insurance company is saying, well, we'll cover the medical costs for the cast and all that stuff, but we're not going to cover your expenses for having you to be taken from your home to work every day in the physical therapy. I'm going, what kind of bullshit is this?
Well, there's where you need a court of equity to look at it differently, because equity's going to look through the technicality and get to the substance. And the substance is that, she's disabled because of the accident. They were the cause of it. And whatever she has to do, hire people to drive her to work, then equity would look at it as, that's the real thing.
And thank you for saying it like that, because that's where I'm coming from. I've seen so far. You know what? I had some pretty good conversations with myself down here in the basement, boy. I'll tell you, man, I had a conversation with a judge and a U.S. Marshal here last week. It's just the best way to go about talking and things talked about, and like you said, where it's just, right, and fair. So, anyway, I'm going to get this letter from my friend tomorrow, and I'm going to, yeah, I know, Gas 9. Yeah, it's true. It's the best way I do. I have a lot of conversations down here. I'm studying. I read something, or I hear something that Chris is saying, and I go, wow. And I have a talk with a judge or some guy on a bench. And I just talk it out logically on what would be fair, what would not be fair, and what would they say, what would not say. But I got to tell you this, though. I've been in court a few times in my life and I understand how they really operate, and Christian knows that, and that helps me understand how the system works a little bit in that regards.
What I found out in the court of equity, the flip-flop happens. The judges do not act like they act on at law.
Yeah, I remember hearing that on the audio calls. It's like that guy was talking about here about 4 or 5 weeks ago, where he said he went in and the judge took off his robe and cleared the courtroom, sat down and talked to him. Were you satisfied that the judge was satisfied that this guy knew what he's talking about with trust and equity and all that stuff? He called the court case back in, he said, and all taken care of, right then and there. So, anyhow, I'll do up this letter tomorrow for this insurance company. I'll make sure that he clearly understands that he's the trustee in the situation, and that she's the grantor beneficiary, and that his client is their client. This insurance company's client is completely liable and guilty. And I won't say much more on this call here like that because I want to keep it private as much as possible. But I'll work around with that. I'll see if I can help out my friend with his situation in a credit card case on the East Coast. But I'll say this one more time again on this call here, folks. If you do your own paperwork, do your own research, and that's why I've been actually pushing my friend on since last Wednesday to this Wednesday. I've been really pushing him, saying, listen to the call, listen to the calls, listen to the call, make up your own paperwork. This is what I would do this and do that. And because I think Christian will agree with me, you can't do other people's paperwork for them because they'll never know when they go to court like that, or if they have to go to court, how they're going to deal with a real life judge when he's asking questions about equity like Dan did. And where did equity come from? And he was stuttering a little bit here. And he said, well, a court of chancery in England when the king had his one guy there create the court of equity for the people because the king was too busy and the king couldn't step in and be the trustee because it'd be a conflict of interest kind of thing, right? But that helped out Dan there a few weeks ago with his child support payments and stuff for him.
Right.
Court. Yeah, just do your own paperwork and just think about all this stuff logically, how this is going to come out. I think you give me some hints here tonight, Christian, how we can do this. And once again, thank you for going on this new endeavor, this new phase of administering the trust through biblical principles. I think, honestly, folks, stay tuned. Don't leave this group. Listen to what Christian's going to tell us, because he's going to give us an awful lot of hints on how we should be administering the trust through biblical principles. And then when somebody comes along and that says that, hey, I have more authority than you do, and I have a right to do this, and you're going to be able to come back to them in a peaceful manner and stand your ground on equity, and they're just going to have to walk away with a head between their legs kind of thing, tail between their legs kind of thing. Because I'm looking forward to hearing this part and what Chris has come up with on his own, so it'd be pretty darn interesting. Other than that, Chris, I don't have a whole lot to say. I did yesterday. Oh, man, if I had you on the phone, if I was on the call yesterday right now, I had probably 15, 20 questions going 100 miles an hour for you. And I can't think of a single one right now. I'm tired right now. So, all right. Spencer's the author. I would read to get the history of equity jurisprudence. Pomeroy references Spencer as an authority on the history. That's good to know. That's what Lisa said. Lisa posted all these dates and times of what? What did she post all these dates and times for? Oh, those are the dates of the top 40. They must be the dates of the top 40. Now I see Gus 11 saying I'm only counting 32 in that list, but I missed something. All right, Lisa, that's a hint for you to create a whole new list of the top 40 audios that is done. By the way, I just actually was organizing probably yesterday was the last day I organized, got all your stuff, all your files and stuff organized for backup purposes, which I did today. And in my reduction folder, Kristen, I have almost 545 gigabytes of files of you and everybody else out there. And I'll tell you right now, I'm to the point, that's what all I need is Kristen Walters' Equity, Black's Law Dictionary, the books of Equity, Pomeroy, Scott, Lewin, Gibson, all that stuff. I'm going to probably take that whole 545. I'll just rack it down. I think right now about 95 or 96 gigabytes of you, but that's because a lot of the audios have been not only duplicated but triplicated because I take those files and I break them down in 3-minute segments so I can take my notes on them and take notes a lot easier. But I think that's after all this time. It kind of reminds me of what I said to you a long time ago about Carl Lentz. And he said he had 2 8-foot stacks of law books. And he said, I don't need all this stuff. And that's where I'm at right now with all my 545 gigabytes of every guru in the last 8 years has been out there that I just realized, no, I don't need anything but your audios, your books, every book.
All the DC stuff that I was studying for approximately about 10 years, listening to everybody under the sun and gathering up everything, the information, a stick of information that I could get. I had boxes of the stuff. When I got into the NTT and the trust stuff, after that, I pitched it all.
Well, what was really amazing was even in the January 17th, 2009 call, or 2010 call, I should say, pardon me, it might have been 2009, I think January 17th, 2009, you were reading the UCC code, even then, you were talking, there were some quotes of equity in there. Now, if I'm correct, though, that equity is probably the legal, the law equity and not really the true equity. Am I correct on that one?
Yeah, we were studying trust, while we were studying the DC stuff, but the more we studied the trust, the more we got into equity and the more we could see the true private side, and that's where it led us.
Yeah, because I remember you calling me up and saying you were excited about that and saying, hey, we've come across a new technology here, new trust technology, right, and that your research is showing you that there's all about trust law.
And November 9 of 2009, that was the point I finally realized that I can no longer go on the DC realm. I got to make the jump cold turkey. I was leaving it behind at that time. That was it. I never went. I do not use it, although I could. Let's put it that way. I do not use it, though.
Right. And like everyone was on the call tonight, it's like Kristen said, it's like get the top 40 audios, listen to those top 40 audios, and then all the other calls.
Everything everybody's wanted so far, looking for it under all these different rocks, they're all looking under the wrong rocks. It's equity. The answer to everyone's problem is in equity.
Well, believe it or not, I was given a call I was given an email by a fellow a friend here the other day, and I actually downloaded the audio. It was a person who actually was able to stop a J.P. Morgan Chase foreclosure, and they haven't finalized it yet, but she did get a win in the court on the at-law side, I'll say it that way. But this lady did fantastic work on all that stuff, and actually I sent this audio to my same friend on the East Coast that's going through a credit card side, because after she was talking, this Tony girl was talking, this other guy came on talking about how he stops debt collectors cold on stuff. I gave it to my friend on the East Coast. I said, listen, this will probably help you out. And when I called him back later on this afternoon, he said, Bob, there's just so much law stuff there. It's just so hard to confuse us. Isn't that the truth? It's nice to hear that these people got to win on stuff on the outlaw side, but I said, you know how much money it took her? 5 years, Christian. 5 years for her to study all this stuff and get a win under the outlaw side. And I'm going, holy smokes. And probably hundreds, if not thousands of dollars to get all her loan history and all that stuff found out where all her loan went to all that stuff. But this lady told me it was right next to sheriff's and how she came up to her conclusion, which is nice. But my friend caught the same thing as I did. It's like you're dealing, and like you just said here, you're dealing with what, 63 million statute of codes? This is ridiculous. It's insanity.
Right.
I mean,
but really, even in the at-law side, to stop them, in its simplest terms, is discovery. And discovery is equitable. So even in the at-law, we're using a discovery process that is in equity.
I want to listen to this call because he said that they should have had standing from the very beginning to bring us into court from the very beginning. If they didn't have standing, then the case is done over and done with.
If you have that already in your possession, that would mean that you had standing when you filed, and you could produce the documents within the first 30 days.
All right, I'll begin on.
You could have had it. If you don't have it, that proves that you didn't have it, because if you can't produce it in 30 days, you don't have it.
Right, then that proves that they're on a fishing expedition.
Yep. Yeah.
Yeah. Okay, well, other than that, I think
Coming
that's
in
about it for
copies. And copies.
Go ahead.
Copies, you can waive copies to treat them as the originals. That's what it does.
One of the things you talk about, too, I thank you for talking about copies like that, Chris. You talk about getting, I heard you in the last few weeks talk about getting the notary and all that stuff. I know right now my friend on the East Coast has a problem with getting notaries and all that stuff. He has a really hard time getting notaries. A lot of notaries don't want to get involved because they look at what he's doing. Oh, you're doing all these patriot stuff and all that stuff. They don't want to get involved with him. Is there any type of...
They're required to do their duty. If they don't do their duty when you ask them to do something, you can have their license pulled.
Okay, I can just tell them that then. Other than that,
you get their bond. You get their bond. All you have to do is claim against them. But usually what we did all the time was we showed them the law that said that they could do this. And then when you showed them the law out of their rules and stuff, they usually did it.
They went ahead and did it, got it done that way. Okay, I'll keep that in mind. Anyway, like I said, I'm almost done, ready to make a decision here because I got you backed up 3 times here. I'll probably delete my main backup of everyone else, and I'll just keep like Black's Law Dictionary, the law dictionaries, all that stuff handy, in your folder like that, and get going on this stuff because this is the time now to get the stuff done. And it's like the way things are going in society right now. To be pretty tense for the next little year or so. We'll see what happens, especially when Basel III kicks in 2015 full time. So, what are your thoughts about what's that?
What's kicking in 2015?
I thought Basel III was supposed to be fully implemented worldwide by 2015.
Oh, the Basel Treaty?
Yeah, the Basel III treaty for the internet worldwide. See, what I thought was really interesting was this. China's been buying off a lot of gold, same with Russia. But last month, if you watch the news, Iraq had bought 36 tons of gold last month. And this, to me, is all because of Basel III, because they all have to have it backing up themselves and do all that stuff. But this is, to me, still not going to solve the problem here, Christian, because simple as this.
Right.
Everyone's doing a general deposit in your bank account, and they don't realize that. All the government
operating equity on the true private side, you don't need money.
Right, exactly. And see, all the government did in 2008 was they just shuffled it, they just hit it through this.
Through the money system, that's how you're being controlled.
Yeah, they hit it through the money system. They did that $1.6 trillion bond and just let out in QE1, QE2, QE3 and all that stuff, and just printed money, because I think all the banks went and spent the people's money when the people don't realize it's not their money when they made the deposit. They gave it to the bank. It became the bank's property under a general deposit.
Yeah.
You know? Yeah. And so the government was just hiding what these corporations were doing so that the truth wouldn't come out, because if the truth came out, the government and all these companies would have been exposed.
Well, that's what Ford said, Henry Ford, back in 1922. He said if the people knew about how the monetary system, what it's based on, by the morning there would be a revolution.
Yep, exactly. But everybody's so involved in all this TV stuff and all these sports and all these pop star singers and Hollywood and celebrities and all that stuff. And
the fiat currency system today is based on you. It's human resource. It's the full faith and credit of the United States. What's that? The people.
Yep. Exactly, based upon us. And yet, where are we going by?
Being tricked to convert your labor into money and all your future labor into money now.
Right. And then on top of that, you're getting your money.
You need to, they're tricking you to convert your labor into money, and then you go buy substance. No, why don't you produce substance and then bypass the money?
Right, and not only that, but when you go and do what you just said, Christian, you just go and you gave your labor away for free because why? It's not yours. It's on a general deposit. I mean, these people are just laughing at everybody, to be honest.
Yeah, they're putting your life, your future labor into special deposit, and then they're doing a conversion on and creating fiat currency.
Yeah. Say that part again. You said they're putting your labor into a special deposit? I thought it was general deposit.
Well, that's what they're tricking you as. But you put your labor into special deposit. You got to withdraw and deposit it, and that's misconstruement.
Yeah, we do that. We put our labor into special deposit when we get paid on that stuff. But
yeah, remember, nobody needs to know that a trust is being formed.
That was one of the first things you said tonight. Yeah, it's so true, eh? So true. It's like, hey,
it doesn't mean it's a trust. It's just that you don't know it's a trust.
Right. Exactly. Hey, can I borrow your pen, Christian? You say, sure. You got my pen. Give it back to me when you're done with it. It's a trust. Done. You give me the pen there. It's done. Transfer.
Yeah. That was it.
Yeah, it's done.
Now, to enforce it as a trust, I would have to know that. Somebody would have to know it was a trust.
Well, that's where you get Lisa to come over and beat me up. Oh man. Yeah, I should get that whip out, man. Other than that, I'm looking forward to this new phase. Okay, we got 2 more weeks of rehashing or summarizing what's all been done. I suspect I'll have a lot more questions like that. My partner and my sweetheart, Karen here, she's been actually very, very sick with a very bad, she almost can't even talk at this point in time. I think I'm coming down with what she has, and that's why I don't feel so good. So I talked to you yesterday. I would have had a whole bunch of questions and comments for you that would have been just super nice. But anyhow, I'll do what I can to do help my friend on the East Coast, and I'll see what I can do about getting this letter done for my friend here, Karen's letter done for her, and make sure this guy understands that this is under special deposit and that she's a grantor and beneficiary, and I'll see what I can do with this so-called law that he gave me. And how he's trying to fight, because that's when I can see, Kristen, what he's doing. He's saying, hey, we need your Social Security number because I need to report it to the Social Security Disability Office. I'm going, hold on, she's not on disability. She's not going to do that. Why? She's got years to go before she retires. So why does he want to give it to her? I'm thinking, well, what he's going to be doing is that he wants to give her notice so that if there's any way that Social Security Disability will step in, because it happened on government property, that when she broke her ankle, that if Social Security Disability's got to kick in, and let's say that Social Security pays the same amount on a monthly basis as what the insurance company would do, and guess what happens? The insurance company's off the hook for paying it. Now Karen would be underneath the terms and conditions of the Social Security Disability for what she can and what she can't do. That's what I have to think of, Christian.
Why don't you ask him?
I'll have to do that. Yeah, maybe I will ask him. See if that's what's going on. Okay, my friend, I look forward to seeing you guys next week. I hope to be in much better shape and have a lot more questions for you and summarization and see if we can get some more things done and help out a few more people, okay?
All right, Bob.
Thanks a lot, dude. Bye. Oh, I'll send him on call, but you are now muted.
Okay, questions, anyone? Star 8. Star 8 to raise your hand, get in the queue line. Star 8, anybody? Who's next? Nobody? Clear board? Oh, gonna be a short night. Star 8, got a clear board here. Anybody got a question? Star 8? Star 8. Anybody question? Star 8.
Hey, how you doing, Christian?
Good. How's this, Chris?
Yeah, Christian Maryland. Well, I was a little late tonight because it's Holy Week, so had a service tonight. So, but hypothetically, I want to tell you about my status hearing that I had. And actually, it was my mother that was up there hypothetically, and so I guess the judge, he was saying she should get an attorney. but he was asking about the gross negligence that was written on the complaint, and I was thinking he was thinking that the amount was too high that was on here, because you in the past you had said, go for $30 million, and that was only for the emotional duress and emotional damages, because we were leaving the fraud and all that for, to go to the equity door as well. Mm-hmm. So it was an interesting experience, and he kind of continued it to hypothetically into June, early June, and I'm surprised that he verbally agreed that the motion, the defendant that put in the motion to strike service process, he pretty much allowed that, which was kind of surprising. But I think I got the sense that he may have been trying to help the defendant a little bit. So that's kind of where that stands.
So what was the motion to strike?
It was a motion to strike service processor. And so this was on a Friday, but I had put the answer in within the time frame on like that Tuesday, the opposition to the motion to strike. And he didn't have it in the case file. He had the case file there, but he didn't have the opposition to strike with him at that point. So it's kind of surprising how he could try to rule on that without even reviewing the opposition to strike.
Well, you have to set a motion for a hearing on that.
Okay.
Otherwise, it'll go dead. It'll go silent. And
so,
the motion to strike will be granted.
Okay. So you have to set a motion for a hearing on that. Okay.
And you have to set a hearing on your motion, on your objection. Like you want to strike the motion to strike, right?
Right.
Well, in order to get that done, you got to set a hearing.
Set a hearing each time. Okay.
Nothing happens in court until you make it happen. Court won't sit there and do anything it's not told to do. And what you want to go after all the time are orders. And the only way you're going to get an order is out of a hearing.
Out of a hearing. Okay.
So you want to go for a hearing that's going to be order to strike the motion to strike.
A hearing for the order for motion to strike the motion to strike. Okay.
Because if you don't, their motion to strike will be unopposed and it'll go through.
Okay.
That's probably why the judge is waiting.
Okay. Well, I'll get on top of that and putting that in, see where that goes. Well, I guess the judge had read the complaint, but he was indicating that he was having an issue with the gross negligence in there. That I put in there. So, put gross negligence because they never created a trust. There's no trust here.
Who said that?
No, I'm saying they never created trust in this case. So I was supposed to deposit a note in the trust within 90 days. That didn't happen.
I'm not quite following you. What about the trust in 90 days? What?
Well, so they come in at it's a deed of foreclosure, a deed of foreclosure trust, but there was no trust ever created.
Oh.
So that was never deposited in the trust.
Talking about our kind of trust. Now you're talking about a statutory trust on a mortgage because you're a trust state.
Right.
Okay. Now that makes sense. All right. Yeah, all right. So there's no trust in existence that they can prove.
Exactly.
Yeah. Now, did you come at them in an action, or did they come at you? Well, usually they don't. They sell the house, but. Yeah.
Well, it came at me, but then you countersued, and so that was what happened Friday with status hearing on the countersuit.
Yeah, because you get into court, and you get into the court by you taking it into court, even though they're trying to take the house by trustee sale.
Right.
And then you get them into court, you make them produce the documentation that they don't have, and then when you don't get it, and the same thing I was telling Bob there, you win because you're doing the equitable discovery. They don't have the documentation. They didn't have standing. There's no trust, and then it's all downhill from there. You win.
Right. Okay. Well, I think we're on the right track.
You got to go in for the discovery.
I'm sorry?
Yeah, got to go in for the discovery. That's done through the court, and when they can't produce it within time limit per the court discovery rules, then they're toast, because then you're going to go in for a motion to compel. And when they can't produce it, then the court is now going to sanction them, and the sanction you want is the dismissal.
Right. All right.
Anything else?
Well, I mean, I want to start trying to work on the paperwork as well to get in the court of equity as well. Because treating it as an executory contract, so nothing else right now. Just still hypothetically on my Social Security thing, I still need to do the show cause. Just haven't got a chance to create that doc and send that off, and then see what happens there. So that situation's still pending. But nothing else right now.
Okay.
All right. Thank you, Christian. Bless you and your wife during this Holy Week.
Thank you.
All right.
Thanks for coming on, Chris.
All right.
Okay, Star 8. Anybody? Questions? Star 8? Who's next?
It's Bob calling here again. Kristen, could you help me out understand a little bit more about this non-debt instrument? I have a couple of questions for it. Do you want to wait till next week or the week after when you want to go do a summarization of it?
No, we can do it now.
Okay. I've been trying to figure out in my head. I listened to the calls. I got my notes, and I'm trying to think. When you say for special deposit 2, what is filled out in that spot, in that space after it says for special deposit 2? Do you make it up to your account? Do you make it up to yourself? Do you make it up to the entity you're dealing with? I got some hypothetical situations that make sense to me,
well,
but I'm not sure.
The material goes with that. I mean, that's a little bit, I need something more to hang a hat on there.
Okay, so you got let's just take a Time Warner cable bill comes in, or I say a credit card bill comes in, and you want to do a special deposit. We'll use my friend's account over on the East Coast. He's got a credit card situation, and he creates
In that case, if it's to somebody like that, I would make special deposit to, and then that entity.
Okay, would it be the law firms coming after him, or would it be the Citibank Visa that's coming after him?
No, when I sign the application or the first signature with.
Okay.
I'm always going to go back to the signature. Where was the signature first applied?
On the application that went to the company he was dealing with.
Yeah, that's the main party. That's the.
Okay. And then on the lower right-hand corner, when you go to endorse or you go to sign on the front, you're signing it as what? The living man on the front, and on the back you flip it over, you endorse it as the I don't want to say authorized representative or as a grantor or beneficiary, but
that's another way I could do it. I'm going to make it like a check made out to me, and then endorse it, and then send it to them, which is good, because it's been endorsed by me. It was made out to me, endorsed by me, and I signed it on it. I made the check out. Now I can give it as a check that's already been endorsed over, and what they would do is they would endorse it under my endorsement on the back and do whatever they want with it. So.
Okay, then I'm on the right track with what I came up with on my own document. So when my friends, I said what you just said, I make it out to myself, sign it on the front.
That's just another way of doing the same thing.
Right. Okay, and then use it on the back. You do it that way because then I don't know how to do it because you make it out to the company. Then the CFO would be the one that would take that and convert it monetize it. You can say it that way, convert it, monetize.
Yeah.
And
So
then
really on the back of that, where I endorsed it on the back, because it was made out to me, when I endorsed it on the back, then under that I would put special deposit to, and then put the entity you want to send it to. That kind of safeguards it for, they're the ones that got the special deposit. Otherwise, it's like made out to cash, and anybody could cash it, say, so to speak.
Right. Let's say that you have an account number.
Once you endorse it, it's like anybody can put their signature on and go cash it, because you endorsed it on the back.
Right. And with that being said, that was one of these probable scenarios that came up with talking with my friend on the East Coast. And I think that's what we should do is you do it up to your first special deposit to yourself. But see, then I thought, well, could we not? And then when you endorse on the backside, you could put down like you said, for special deposit to account number so-and-so at Time Warner Cable. Because you don't want to make sure it goes into your account to be applied towards the account itself, wouldn't you?
Yeah, you might be able to do it that way.
Because, like you said, you don't want to go up to any Tom, Dick, and Harry after you endorse it. You could do it your way, too, for special deposit to, let's say, Time Warner Cable, or I say, how about we do this? On the front side, on the front side, you can put down for special deposit to a Time Warner account number 12345. Then you sign the front of it, flip it over, then you endorse it, and endorse it, and that way also they would have to apply that special deposit.
Make it out to CW, and then I would sign it on the face on the lower right. CW. I signed it. Now I flip it over. I endorse it CW, and then I make it special deposit to Time Warner account such and such.
Just like doing yourself a cash check.
Yeah.
Okay, exactly. So I'm on the right track with that. Now, I have that special paper that when you photocopy or you scan it, it comes up the words in the background. I think mine says photocopy. You can get the ones with the void and all that stuff. I was thinking about using that as for my non-dead instruments. What are your thoughts about using paper like that?
Check paper? Yeah, that's okay.
Because the other thing I figured was this. We know from the Federal Reserve publications, Modern Money Mechanics, and all those other Modern Money Mechanics.
Toilet paper. Or you can use an envelope, anything, as long as you can write on it. I can take their bill that they send me and then write over the face of that, turn it into a check, and send that back to them as special deposit.
Yeah, you were saying that they're looking for words and numbers, and that's on that January 17, 2009 call. You're talking about that. They're looking for words and numbers. Even if you just sign your signature to it, the person on the receiving end, most likely the CFO, he would know what to do with it to fill out the rest of the stuff. And like you said on the call, on that particular call, he said, you have no idea what they're putting in there after you sign it.
It's what's on top that counts, and what's on top is my thing that I got sideways across the whole thing.
Yeah. The reason why I asked you about that special paper I bought probably 3 years ago like that, was because
we did that. We had the special ink, and so we put the bank numbers on it and all that stuff. We don't have to do that stuff.
Right. I know that part, but I'm just saying, you know how they fractionalize and all that stuff. Well, my other thought is this. See, you have to understand, people, when you give them that, they can monetize that, but at the same time, is it your belief at the same time, are they not going to be able to fractionalize that instrument?
Well, if you give them broad powers to do the special deposit and extinguish the debt, they may create more than what they need.
Okay. And
you restrict them in some ways and say that there's nothing else supposed to be used of this special deposit other than for the special deposit that onto that account to pay that particular bill or that amount.
Right. Okay. That's like the trust indenture.
It can be limited, or it could be broad. Either way, depends how you want to do.
If you say, hey, Mr. CFO, I'm going to be a really nice guy here. I know you're probably going to fractionalize this, so just take this and monetize it, apply towards my account if you want to.
There's their fee.
Yeah, and there's your fee for it. But hey, but if you get online with me, I'm going to ask for all that fractionalization back as a penalty.
It's like, okay, I know what's going on, you know what's going on. Now here, since we both know, hey, here's your fee, stop playing games, do the special deposit, do the extinguishment, and you can have the balance of the funds.
Right. And, you think about that, what's been going on, because that's the CFO, that's why they're paid so high, because they're paid to keep quiet.
Yeah, but whose money is they're paid with?
Ours.
Yeah.
Yeah, but that's why they're paid to keep quiet, though, too.
All because he knows it's a trust.
Yeah. Those are the trust and knows how that they're like a bank. The CFO is like a bank, and they're the ones who want to monetize that and do it.
Banking.
Yeah, private banking and private bank.
All trust.
Now, I asked you a question about 3-4 years ago. I asked you, if you appoint somebody to be the trustee, they could actually say, no, I don't accept that position. I think last week and the week before, I talked about that, where I did find on the one website where it said that on the Department of Treasury website, where it said that if you're a CFO, you must be duly registered with the Secretary of Treasury of the United States Department of Treasury and prove that you have the qualifications and understanding and knowledge to fulfill the positions and duties of such a position. And I'm sitting there thinking, like, well, what if you give it, what if you give it to a person? See, I at this point in time, because I can't see not giving it to anyone else other than someone like a CFO. Because if you give it to, if you give it to somebody else that has no clue what the paperwork is,
special. If you go to normal channels, you go through the regular doors, and all those people say you can't do any of that stuff.
Right. And that's what I was coming up with. I was telling my friend, we can't go through that way. That's why you have to deal with that one particular person. Now, rather than putting down a specific name, because that person could actually leave that position, say, next day, 2 days, a week, 2 months, 5 years later, whoever knows like that, I was thinking about putting down for the occupant of the position or occupant of Chief Financial Officer as the trustee.
How about both? Mr. So-and-so and his successors.
I came up with that too, but I didn't know if I could do that or not. So I can use that, and his successors. Okay, I can see that.
But then you'd probably have to have him in there twice. Once in his personal capacity, one in his official capacity, and then any successor.
Okay, personal, professional, successor capacity. Okay, that's cool. All right, so I'm pretty well set on how to do all this stuff. We got to get the trust made of that. I looked over your documents again this past week. You are talking about the one part about I just lost track what I was just going to say. My daughter's coming down here. Hi, sweetie. How you doing? You came down to see me? Oh, good girl. Come here. Come on. Come on. Good girl. Okay. Talking about the recording of it. Like, so you do the newspaper, you can do a Secretary of State, you can do the county recorder. Is there anyone else you can think of that you could possibly do that could be a witness, a possible witness in your mind, besides those three entities?
Yeah, proto-notary, affidavit by somebody else.
An affidavit by somebody else? Okay, does that person have to be a person? Can they just be a person, like a thing?
Yeah.
Like an executive? Could an executive be that?
You just need to create another record.
Pardon me?
You just need a witness to create a record.
Okay. So a witness create the record. Okay, so a witness create the record. Okay, so like that. You get the seal put on. Get that done. It's two witnesses, and there we go at that. And of course, we saw the problem with the judge. When the judge is in court, he's a judge at that point in time. But when he goes home at night, he's either a dad, a husband, or a man. At that point there. Okay, I think that's all my question I have for the non-debt instrument. I'm looking forward to doing this. I really see how we can sit there and take an item and monetize it, have it apply towards their account so we don't have to ever worry again about paying a utility bill or a credit card bill.
Actually, do the monetization, only they have the licensing to do the monetization, but I don't really care what they do with it. I'm just giving them conversion instructions.
Right, conversion instructions.
They convert it into anything that they want, that they need, and that's what I'm giving them broad powers to do.
And as long as they credit your account.
Well, that would be the duty, yeah.
Yeah, that would be the duty to do that. So you convert it, however you got to do that, monetize and apply towards the account like that. If you fractionalize it, you can keep 5 nights and then send 4 nights back into my account. That'd be one way of doing it. You'd still be in the positive every month.
Yeah, no, don't
okay.
If they send you a check back for the amount that you want extinguished. But it's what you do with the check afterwards. Because really, they did the conversion for you, and then they send you a check. And what do you do with the check? You certainly don't go cashing it.
Well, I think what you would do is you would endorse and send it back to them. So here's your money.
Endorse it and send it back to them.
I think, matter of fact, I'm
business with me.
Yeah, I think, as a matter of fact, that's what was happening with you were talking about at one point the 1099 OIDs and the one call I have of you. That's what was happening to a lot of people. They were getting checks back and they were cashing them and not endorsing and sending them back to the IRS. That's what's along the same lines, is it not?
Yeah, I mean, you got the thing converted, you got the debt extinguished. Then if you take and keep the check that they're sending, now you got twice of it. Now there's no balancing the books. It actually doubles up.
Right.
It's quite out of balance than what it was original amounted to.
You made the comment twice here tonight, or at least once for sure. I know that when you operate in equity, there is no such thing as money. And that's basically what you and I are talking about even right now. There is no need for money. You just sell the debt and let them do whatever they got to do, because all money is just a medium of exchange.
Yeah, they're the bookkeepers. It's all accounting.
Yeah.
Just numbers on a ledger sheet. That's not substance. That's all fake.
Right. It's just like a keystroke on a keyboard and all that stuff. That's all it is.
If I got a sided ledger and I put 50,000 on one side plus, and I put minus 50,000 on the other side, what have I got?
Zero.
So if I put 100 million on plus on the one side and 100 million minus on the other side, what have I got?
Zero. Say that again. Yeah, zero. You talked about that upside down T. Do you recall that?
Yeah. But the thing is, if we're using the minus side as money, they're still holding the plus side that balances out to zero.
Yeah.
What have we got?
Yeah.
We got fiction. Nothing. We got no money. There is no money.
Everybody's so worried about this stuff. Now, let me ask you a question. In reality, though, I mentioned I gave a strong hint tonight that there's this. As much as I want to help everybody out there, Chris, I just realistically, I don't think it's a possibility to do that. I think people are just too wrapped up in themselves, wrapped up in their.
Really, when the two are merged together, you got zero. That's trust.
Right. Okay, I understand that.
Technically, it's always zero. It's always merged because it always comes down to zero.
They have to balance the books every night.
Yes.
Yeah.
It's always got to balance to zero.
All right. Well, I think I got some good ideas here on my special deposit non-debt instrument like that. Get that taken care of. Again, I got to learn a little bit more about the trust stuff and set up like that. Intent transfer, the non-UCC 1, non-UCC 3, claiming the property, notice of interest, statement of interest. I got that. Some of that stuff is under my belt. I got to get more of it under my belt, a lot more understanding. But I'm at a very good point right now. I think this is a perfect time for me to come back into, I don't say come back into your life, but I mean as a friend, because I'm excited. I really am. I just 2 more weeks of summarization of NTT is going to be great. And then I think by that time I'm just rocking and rolling with this stuff. And I'm going to have a whole hell of a lot of questions for you, but I have to do that privately, I guess, or something like that. And you're going to want this biblical stuff and how how to administer the trust through biblical principles. And I don't see how anyone listening to the call tonight cannot see how that is going to be so beneficial to helping us.
If we were living an equitable life and we didn't create any contracts, we wouldn't be responsible for the contracts when they fell into a breach.
Yeah.
And you wouldn't be in court.
Yeah. Wouldn't be in court, wouldn't take care of all that stuff. And
so if I stay in private, I don't mix in with the public, then there's no reason for me to be hauled in under public anything.
Well, you mentioned I think you mentioned there's one thing that if you're subpoena and if you're summons is for the fictional thing, but subpoena is for a man. Do you recall that?
Yeah, but today they all summons everything.
Well, it's always for the fictional thing. I command you to appear. That's what my friend got in his paperwork. I command blah, blah, blah to appear before this court. I was saying, if you go there, you just get a surety for the debt. I mean,
that would be under DC contract, but then this wasn't a DC contract, so I'm applying trust, and I'm not the surety for the debt. I am either the grantor or the beneficiary.
Right. In our case,
one of the three.
Right, exactly. Yeah, and get that taken care of. Well, listen, dude, my head's hurting. I think I'm coming down. My Karen's cold here, so I better take care of myself. Thanks for letting me ask this one more question on the call here tonight. I wish everybody a good week, and I'll look forward to seeing you guys back next week.
Okay,
Thank
Bob.
you.
Thanks.
Thanks, dude. You are now muted. Oh, if you have questions here.
Okay, who's next? Anybody? Oh, we got an empty board again. Star 8, anybody? Question? Star 8, question, anybody? Star 8, question. Okay, we're going to count them down. Star 8, going once. Question, anybody? Star 8. Anybody have a question? Press star 8. Star 8 going twice. Anybody have a question? Press star 8. Last call. Star 8. Anybody? Nobody? Okay, that's it. Star 8 3 times. All right, so we have 2 more shows left. So anybody have their questions? Get them written down. So I appreciate it for everybody that showed up, and we'll see you next week, same time, same channel, and we'll go on from here. So everybody have a great week. Night all.